Shifting gears, the new developments in the Luigi Mangioni case. His defense team claims that prosecutors have intentionally violated their client's rights, his rights to a fair trial, by releasing his handwritten journal entries. They say it was unnecessary and designed to bias the public. So how will this impact that case? Let's bring in criminal defense attorney Brian Claypole. Thank you so much for giving us your thoughts on a Saturday morning. I want to get right to this. Here's what the filing says. The prosecution has intentionally violated Mr. Mangioni's rights to a fair trial by unnecessarily publicly releasing his alleged journal. The defense has provided irrefutable evidence that the search of Mr. Mangioni's alleged backpack may be illegal and its fruits may therefore be suppressed. The prosecution has cherry-picked the most facially prejudicial information from the materials that may never see the light of the courtroom. Why? The only rationale that makes sense is that the prosecution hopes to bias the public against Mr. Mangioni and undermine his right to a fair trial. Now, this is a suspect, a defendant in this case, that has faced a certain amount of support among the public. So what do you make of his lawyer's assessment of what has been released?
Hey, Molly, great to be with you on a Saturday. Yeah, what's good for the goose is good for the gander. What do I mean by that? Well, like you just said, Mangioni's been getting a ton of favorable publicity. He's gotten a boatload of donations, I think over $500,000, if not close to $1 million now, to help fight for his defense, because his attorneys have been out there proclaiming his innocence throughout this case. And look, I've been involved in high-profile criminal cases, and it's not uncommon to have some information released during a case, Molly, or prior to trial. There's no complete gag order in this case, so nobody's violated a gag order. And look, I think the lawyers for Mangioni need to be careful here, because what they're doing, Molly, is they're not going to try to exclude everything in this diary, it looks like. And if they do that, that's a mistake, I think, because there could be some information in that diary that could have possibly helped show that Mangioni was suffering from, his back injury, and he was so, upset about his back injury that may have contributed to him, carrying out this heinous act. If they get this whole diary thrown out of court, then they're not going to be able to rely on any of those other thoughts that Mangioni documented.
Yeah, and on the note of the kind of public support he's been receiving, here's another part of the filing from his lawyers. Despite law enforcement's attempts to portray Mr. Mangioni as a terrorist and a revolutionary anarchist intending to inspire violence, over 30,000 different people have donated to his fund, leaving positive messages. In fact, the top 5 words left in the comments section of the fund are love, hope, support, people, and free. Keeping in mind, of course, that as searches perhaps of this backpack were done, that there was a manhunt that had gone on for this individual. He didn't come forward, turn himself in, that there was a period where authorities were very concerned about a danger to the public.
Yeah, Molly, I think what's important about what you're saying is Mangioni allegedly said, I didn't feel any doubt that this was justified. That's allegedly in the diary. And it says further that it allowed him time to learn more about UHC, right, the healthcare company. And those two comments, Molly, are crucial in the case if they get admitted. Why? Because they prove premeditation. They prove alleged terrorism, that he's trying to rally people to come against healthcare companies. And then most important, what it does is, I think it guts really the only defense he has in this case, which is diminished capacity. What's that? His lawyers could have argued that he was so mentally incapacitated from his injury, Molly, that he really couldn't form the requisite intent to kill. It lowers the charge to manslaughter rather than murder. It's not a complete defense. But look, that entry in and of itself would literally gut that argument. So I think that's a big mistake on the part of Mangioni's lawyers. And then, like you said, look, you've got all these people donating, giving money. What his lawyers are hoping to get, Molly, is what's called juror nullification. Mm-hmm. That means they want these jurors to just ignore what he allegedly did and feel sympathy for him, and then rule for an acquittal based just on that.
All right, there was another big legal story this week, the Karen Reed case. I covered this trial extensively. This Massachusetts woman accused of killing her police officer boyfriend in Massachusetts, found not guilty of murder in this, her second trial. The retrial, also not guilty of manslaughter. What do you make of the verdict?
Yeah, hey, Molly, look, the jury got this one right. Why? Because if you as a prosecutor are having trouble proving what the manner of death was, what I mean by that is what actually caused the death. For example, usually in murder cases, you have that. It's definitive. It's either a gun, a knife, a fist, a rock hit somebody on the head. Here, I mean, the prosecutors could not prove beyond a reasonable doubt the manner of death, whether it was the SUV or somebody in the house or somebody otherwise who killed O'Keefe, and that is really a daunting task here. And to me, the two most powerful witnesses in the case, the medical examiner. She's an independent witness, Molly. She's actually hired by the county to do the autopsy, and she comes in and says, "Look, I can't give you a definitive manner of death." That was a game changer. And then look, they attacked the investigation. It was done, I think, very haphazardly, the way they collected blood, the evidence allegedly showing up later in the day. And then also you have this snowplow driver who I thought was a game changer too. He comes in, he doesn't have an axe to grind. He says at 2:40 a.m., I was snowplowing right in front of the house. I didn't see a body next to that flagpole. Why is that important? Because that suggests that O'Keefe was still in the house and that something bad happened in the house to cause his death. So look, I think the jury did get this right. And, you know, I give them credit too for reaching this verdict.
Yeah, it was fascinating to watch all this. You're talking about Lucky Loughran, the plow driver who drove by, as you mentioned, kind of speaking to the two theories that the defense put forward. In the first trial, they focused a lot on the possibility that Karen Reed was being framed. That was their argument. In this second trial, they really drilled down on arguing that there simply was no collision, that Karen Reed did not hit John O'Keefe. And it seemed that the jury heard that argument from the defense. What do you make of it?
Yeah, great point, Molly. I think that's an excellent point. There's two big game changers, I think, in the second trial that were different than the first trial. You're right. Reed's lawyers did a great job of saying, look, if an SUV is backing up and this SUV hits O'Keefe and then he falls and hits his head on the cement, causing his death. Remember, it was blunt force trauma to the head that was the cause of death. Then you would expect, Molly, some type of injury in the torso, some type of injury in the lower leg, right? Based on the height of the SUV, it would have impacted his upper thigh area or in the torso area. And there were no physical injuries in either of those areas. So that really suggests to the jury that it's impossible for the SUV to have hit him like that, right? I mean, that was a big one. And then one last point I wanted to make that was important. What they did before the jury instructions were read, Reed's lawyers changed their defense. They didn't want to blame it on somebody else in the house, which I think was a smart move. They didn't have enough evidence of that. So all they did is they had a jury instruction read that the police department only investigated one person throughout this entire investigation, and that was Karen Reed. And I think that was a smart move on their part.
Brian Claypool, thank you so much. Greatly appreciate your insight, particularly on these two big cases, major legal breaking news this week. We appreciate it.
Yeah, thanks, Molly.